Understanding the legal landscape of firearm transportation is not merely about compliance. It is about preserving your rights and ensuring your ability to continue lawfully exercising them. For the responsible citizen who has taken the significant step of legally possessing a firearm for self-defense, sport, or collection, the journey does not end at the doorstep. The moment that firearm enters a vehicle, it enters a complex legal environment governed by a patchwork of federal statutes, state laws, and local ordinances that can change dramatically with the passing of a state line. Many gun owners invest considerable time and resources in understanding the use and safe handling of their firearms, yet comparatively little time is spent understanding the intricate web of transportation laws. This imbalance can lead to situations where a routine traffic stop or a simple road trip transforms into a legal ordeal with lasting consequences. The law does not grade on a curve. It does not offer partial credit for good intentions. It is therefore essential to approach the topic of transporting firearms with the same seriousness and attention to detail that one applies to their safe handling and storage. With that in mind, consider this. If you were to cross into a state with different firearm laws right now, would you know with certainty whether your current method of carrying or storing your firearm in your vehicle is lawful? Take a moment to think about that, and if you feel confident in your answer, share in the comments what resources you use to verify the laws of the states you travel through. The foundation of lawful firearm transportation rests on a principle often misunderstood by even seasoned gun owners: the interplay between federal protection and state authority. At the federal level, the Firearm Owners Protection Act, codified as 18 U.S.C. Section 926A, provides a critical, though limited, shield for those traveling with firearms. This statute explicitly entitles a person who is not prohibited from possessing a firearm to transport it from any place where they may lawfully possess and carry it to any other place where they may also lawfully possess and carry it. The conditions are specific and must be strictly adhered to. During such transportation, the firearm must be unloaded, and neither the firearm nor any ammunition may be readily accessible or directly accessible from the passenger compartment of the vehicle. In vehicles that do not have a compartment separate from the driver's compartment, such as a trunk, the firearm and ammunition must be contained in a locked container other than the glove compartment or console. This federal law was designed to ensure that citizens could travel between states without being ensnared by the restrictive laws of intermediate states through which they must pass. However, the practical application of this law has been far from straightforward, and understanding its limitations is the first and perhaps most crucial lesson in avoiding legal missteps on the road. The first major mistake that gun owners frequently make is a failure to appreciate that FOPA is not a blanket license to carry, but rather a narrowly defined affirmative defense that often must be asserted after an arrest has already occurred. The law guarantees the right to transport, but it does not prevent law enforcement from detaining an individual who is found to be in possession of a firearm in a jurisdiction with stringent laws. There are numerous documented cases of lawful gun owners who complied with FOPA to the letter, only to find themselves arrested, jailed, and facing criminal charges. Consider the case of a Utah resident flying through Newark Liberty International Airport whose flight was delayed. He collected his baggage, which contained a lawfully owned, unloaded handgun properly stored in a hard-sided, locked container, spent the night in a New Jersey hotel, and attempted to recheck his bag the next morning. Upon declaring the firearm, he was arrested for illegal possession under New Jersey law and spent 3 days in jail before making bail. Similarly, a Florida attorney who properly declared his firearm in checked luggage at LaGuardia Airport was arrested on the spot for not possessing a New York handgun license. In both instances, the individuals were in full compliance with federal transportation law, yet they became criminal defendants because local authorities either did not recognize the federal protection or were not bound to honor it without a court battle. These cases illustrate the harsh reality that FOPA does not provide immunity from arrest. It provides a legal defense that must be raised in court, often at great personal and financial cost. The responsible gun owner must therefore recognize that while federal law offers a theoretical right to transport, the practical exercise of that right requires navigating a landscape where local enforcement practices can vary widely, and where an arrest, even if ultimately dismissed, can be a life-altering event. Building upon the complexities of federal protection, the second common mistake involves a fundamental misunderstanding of how state laws define lawful possession within a vehicle. The notion that a firearm in a vehicle is simply an extension of one's person for carry purposes is dangerously incorrect. State laws governing firearms in vehicles are incredibly diverse, reflecting a spectrum of policy approaches. Some states, like Alaska, Arizona, and Kansas, allow any person who can legally possess a firearm to carry it loaded and concealed within their vehicle without a permit, treating the vehicle as an extension of the home or private property. Others, like Georgia and Mississippi, similarly allow permitless carry in vehicles, recognizing a broad right to keep a firearm accessible for self-defense while driving. However, a large number of states impose significant restrictions that can easily ensnare an uninformed traveler. For instance, California requires that handguns be unloaded and stored in a locked container, and it specifically excludes the glove compartment and utility compartment from qualifying as such a container. In Florida, a firearm must be securely encased or otherwise not readily accessible for immediate use, which generally means it must be in a closed glove compartment, a snapped holster, or a zippered gun case. Indiana mandates that handguns be unloaded, not readily accessible, and secured in a case. Massachusetts takes a particularly strict approach, generally prohibiting the possession of a loaded firearm in a vehicle without a state-issued license to carry, a permit that is difficult for non-residents to obtain. The variance is so pronounced that even within the same region, the rules can be diametrically opposed. In Pennsylvania, a person without a license can carry a loaded firearm in their vehicle as long as it is not concealed on their person, and they are not in Philadelphia. Whereas in neighboring New Jersey, the presence of a firearm in a vehicle without a valid New Jersey permit is presumptively illegal. This patchwork creates a high-stakes environment where a simple drive across a state line can turn a lawfully stored firearm into a prohibited weapon. The mistake is assuming that because one's home state allows a certain practice, neighboring states will as well, an assumption that can lead to arrest, confiscation of the firearm, and a permanent criminal record. The third mistake, and one that is entirely preventable, concerns the handling of traffic stops when a firearm is present in the vehicle. A traffic stop is inherently a high-stress encounter for both the motorist and the law enforcement officer. When a firearm enters that dynamic, the potential for misunderstanding escalates exponentially. The primary error gun owners make in this context is failing to manage the officer's perception of risk through deliberate, calm, and communicative action. Officers are trained to be hyper-vigilant about sudden movements, especially towards areas where weapons might be stored. If a driver, upon being pulled over, immediately reaches for the glove compartment to retrieve their registration and insurance, and that glove compartment also contains their handgun, the officer has no way of knowing the driver's intent. What the driver perceives as routine compliance, the officer may perceive as reaching for a weapon. This split-second misunderstanding can have tragic consequences. The safest and most responsible approach involves a few key principles. First, upon being stopped, the driver should immediately place both hands on the steering wheel in plain sight and wait for the officer to approach. Second, when the officer initiates contact, the driver should calmly and immediately inform the officer that they are a concealed carry license holder or that there is a firearm in the vehicle and ask for specific directions on how to proceed. For example, one might say, "Officer, I want you to know that I have a valid permit and I am currently carrying a firearm. How would you like me to proceed?" This statement serves multiple purposes. It demonstrates a good faith effort to comply with the law and respect the officer's safety. It also eliminates the element of surprise, which is a significant factor in officer safety. In many jurisdictions, there is also a legal duty to inform, making such disclosure not just prudent but mandatory. In states with a duty to inform, failure to disclose can result in the suspension or revocation of one's permit, independent of any other charges. The responsible gun owner recognizes that a traffic stop is not the time to test the limits of one's rights, but rather a time to de-escalate a potentially tense situation through clear communication and calm, predictable behavior. The fourth mistake moves from the procedural to the substantive, involving the actual use or threatened use of a firearm in a manner that exceeds the legal boundaries of self-defense. While this may not seem directly related to road travel, it is critically relevant because vehicles are mobile, and the situations one encounters on the road, from road rage incidents to breakdowns in unfamiliar areas, can quickly escalate into perceived threats. The legal framework for using deadly force is stringent and unforgiving. In the vast majority of jurisdictions, the use of deadly force is justified only when an individual reasonably believes it is necessary to prevent imminent death or great bodily harm to themselves or another. This is often framed as the necessity to meet three elements: ability, opportunity, and imminent jeopardy. The attacker must have the actual ability to cause serious harm, the opportunity to use that ability, and their actions must demonstrate an immediate intent to do so. When any of these elements are absent, the use of deadly force becomes unlawful. A common error rooted in a misunderstanding of this framework is the use of a firearm to protect property. One cannot legally shoot someone who is stealing a car from a driveway or running away from a gas station with cash, even if that property is valuable. The threat is to property, not to life, and the law draws a bright line at that distinction. Another frequent error is the firing of warning shots. While the intent may be to de-escalate a situation without harming anyone, warning shots are legally problematic for several reasons. They represent a use of deadly force that is not directed at a specific identified threat, meaning the shooter cannot guarantee where the bullet will ultimately land, posing a danger to innocent bystanders. Furthermore, in the eyes of the law, a warning shot can be construed as an admission that the situation did not yet warrant the use of deadly force, undermining any subsequent self-defense claim. If one is justified in using deadly force, the law generally expects that force to be directed at the source of the threat, not into the air. For the traveler, this means that an encounter on the road, whether it involves an aggressive driver or a suspicious person at a rest stop, must be navigated with a clear understanding that the firearm is a tool of last resort for the preservation of life, not for resolving disputes, asserting dominance, or protecting possessions. The decision to draw or use a firearm carries with it the immense burden of justifying that action to law enforcement, a prosecutor, and potentially a jury, all of whom will scrutinize the events in the calm, deliberate light of a courtroom, far removed from the stress of the moment. The fifth and perhaps most pervasive mistake involves the failure to conduct adequate pre-travel research and planning. In an era of instant access to information, the resources available to the traveling gun owner are vast, yet they remain underutilized by many. The laws governing firearms are not static. They evolve through legislative sessions, court rulings, and changes in local enforcement policies. Relying on information from a few years ago, or even from a well-intentioned but uninformed friend, is a gamble with one's freedom. The conscientious gun owner treats travel planning as an integral part of the journey itself. This involves consulting multiple sources to build a comprehensive understanding of the legal landscape ahead. Primary sources, such as the official websites of state police or attorneys general, can provide authoritative information on state-specific carry and transportation laws. Secondary sources, including regularly updated guides from reputable legal experts and organizations, can offer practical insights and highlight recent changes. It is also crucial to understand the concept of reciprocity for those who hold concealed carry permits. While a permit from one state may be honored in another, the terms of that reciprocity can be complex. Some states honor all permits, others honor only permits from states with which they have a formal agreement, and still others have no reciprocity at all, requiring the traveler to either obtain a non-resident permit from that state or strictly comply with that state's transportation laws for unloaded and secured firearms. The previously mentioned FOPA provides a baseline for transportation through restrictive states, but it does not allow for the carrying of a loaded, accessible firearm for self-defense. Therefore, a traveler passing through a non-reciprocal state must decide whether to stop at the border, unload, and secure their firearm in compliance with that state's laws for mere transport, and then rearm upon entering a more permissive jurisdiction. This requires not only knowledge of the law, but also a disciplined routine for securing and accessing firearms that does not violate any statutes along the route. The mistake is assuming that a permit from one's home state functions as a universal pass, an assumption that can lead to arrest in states like New York, New Jersey, Maryland, or Massachusetts, which are notoriously restrictive and have historically been hostile to out-of-state permits. Furthermore, the legal responsibilities of a gun owner extend to understanding where one cannot carry, even with a valid permit and even within one's own state. The concept of gun-free zones is pervasive and often non-intuitive. Federal law prohibits the carry of firearms in certain locations, such as schools and post offices, regardless of state permits. State laws add additional layers, commonly banning firearms in courthouses, airports beyond security checkpoints, establishments that serve alcohol for on-premises consumption, and private property where the owner has posted clear signage prohibiting firearms. The mistake many make is assuming that a concealed carry permit grants them the right to carry anywhere, ignoring these specific statutory and proprietary exclusions. For the traveler, this is particularly treacherous because the locations of these prohibited places may be unfamiliar. A rest stop that includes a post office, a highway that runs through school property, or a restaurant that serves alcohol in a state with a specific statute against carrying in such establishments can all become legal traps. Ignorance of these specific prohibitions is not a defense, and carrying in a prohibited place can result in the immediate revocation of one's permit, criminal charges, and the permanent loss of gun rights. The responsible traveler not only researches the carry laws of a state, but also the specific statutes defining prohibited locations and exercises heightened vigilance when entering any building or establishment whose legal status is uncertain. The intersection of firearms and alcohol consumption presents another significant area of legal exposure for gun owners on the road. While the laws vary by state, the general principle is that combining alcohol and firearms is a recipe for legal disaster. In many jurisdictions, there is no specific statute that sets a numerical blood alcohol limit for carrying a firearm, as there is for driving a vehicle. However, carrying a firearm while under the influence can lead to charges of disorderly conduct, brandishing, or even reckless endangerment, particularly if the individual's judgment is impaired in a way that leads to poor decisions. Furthermore, many states have laws specifically prohibiting the carry of a firearm in establishments that are primarily devoted to the sale of alcohol for on-premises consumption. Even in states where such carry is technically legal, the presence of alcohol dramatically complicates any self-defense claim. If a shooter has been drinking, a prosecutor will argue that their judgment was impaired, that they perceived a threat that a sober person would not have, and that their actions were therefore unreasonable. This argument can be devastating to a self-defense case, as the reasonableness of the actor's perception and response is almost always the central issue. For the gun owner traveling through unfamiliar areas, stopping for a meal at a restaurant that serves alcohol requires a conscious decision. If one is carrying, the safest and most legally sound choice is to abstain entirely. Even one drink can provide a prosecutor with the ammunition needed to paint a lawful act of self-defense as the reckless action of an intoxicated individual. This is not a matter of personal tolerance or judgment. It is a matter of preserving the legal ability to argue self-defense without the cloud of alcohol impairing one's credibility. Another layer of complexity is added when the firearm in question is not a standard handgun or long gun, but rather a firearm regulated under the National Firearms Act, such as a short-barreled rifle, short-barreled shotgun, machine gun, or destructive device. The transportation of these items across state lines is subject to an entirely separate and much more stringent regulatory regime. Before transporting an NFA firearm interstate, one must generally receive prior authorization from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. This is not a mere formality. It is a legal requirement with criminal penalties for non-compliance. The application process involves submitting a request to the ATF detailing the complete description of the firearm, the need for transportation, the mode of transportation, and evidence that possession is lawful at the destination. Only after receiving specific authorization from the ATF may such transportation lawfully occur. The traveler who assumes that their NFA item, lawfully possessed at home, can simply be loaded into the car and taken on a road trip is making a potentially felonious error. This is an area where the federal government retains exclusive and stringent control, and where the consequences of noncompliance are severe. It underscores a fundamental principle of responsible gun ownership. The more unusual or highly regulated the firearm, the greater the burden on the owner to understand the specific laws governing its movement. The legal landscape for traveling gun owners is also shaped by ongoing constitutional challenges that could redefine the relationship between state authority and individual rights. The Supreme Court's decisions in District of Columbia v. Heller and McDonald v. City of Chicago established that the Second Amendment protects an individual right to keep and bear arms, and that this right is applicable to the states. More recently, in New York State Rifle and Pistol Association v. Bruin, the court articulated a new test for evaluating firearm regulations, requiring that they be consistent with the nation's historical tradition of firearm regulation. This decision has spawned numerous challenges to state and local laws, including those affecting non-resident carry permits. A coalition of 25 states recently filed an amicus brief with the Supreme Court in a case challenging Massachusetts' restrictive licensing requirements for non-residents, arguing that the Second Amendment does not stop at state borders and that citizens should not face criminal charges for exercising constitutional rights while traveling. The outcome of such cases could, in the future, simplify the current patchwork of laws by establishing a more uniform standard for the recognition of carry permits across state lines. However, for the present moment, the law remains a complex and often contradictory collection of state-specific rules. The responsible gun owner must stay informed not only about current statutes, but also about significant legal developments that may signal changes on the horizon. This requires a commitment to ongoing education, whether through legal publications, reputable firearms training organizations, or consultation with attorneys who specialize in Second Amendment law. In considering the practical application of these principles, it becomes clear that preparation is the single most effective tool for avoiding legal mistakes. Preparation begins with a mindset that treats the legal aspects of firearm ownership with the same gravity as the safety aspects. Before any trip that involves transporting a firearm, a comprehensive review of the laws of every state along the route and at the destination is non-negotiable. This review should include not only whether a permit is honored, but also the specific requirements for vehicle storage, the locations where carry is prohibited, and the duty to inform law enforcement during a stop. It should also include a contingency plan. What happens if there is a mechanical breakdown that requires an overnight stay in a restrictive state? How will the firearm be secured in a hotel room to prevent access by cleaning staff or to comply with local laws? What is the protocol for safely securing the firearm if one must leave the vehicle for an extended period in an unfamiliar location? Thinking through these scenarios in advance transforms the abstract knowledge of the law into a practical, actionable plan. It allows the gun owner to make decisions calmly and deliberately rather than reacting under pressure. Furthermore, the choice of equipment can play a role in legal compliance. A high-quality, lockable safe that can be securely mounted or cabled within a vehicle provides a consistent and legally compliant method of storage that can be used across multiple jurisdictions. If the firearm must be unloaded and inaccessible, as required by FOPA or by the laws of a particular state, a secure vehicle safe ensures that this requirement is met without ambiguity. It also provides protection against theft, which is a significant concern for travelers who may be leaving their vehicle unattended in public areas. Investing in such equipment is an investment in both legal compliance and responsible ownership. Similarly, maintaining a digital or physical file of all relevant permits, as well as printed copies of state statutes or reciprocity agreements, can be invaluable if questioned by law enforcement. While a printed statute does not carry the force of law, it can serve as a reference point for discussion and demonstrate a good faith effort to comply. The key is to approach travel not as a break from the responsibilities of gun ownership, but as an extension of them, requiring the same level of diligence, awareness, and respect for the law that one exercises at home. Ultimately, the responsibility borne by the gun owner is profound. It is a responsibility not only to oneself and one's family, but to the broader community of lawful gun owners, as each legal misstep, each arrest, each tragic misuse of a firearm becomes part of the public discourse and fuels arguments for more restrictive legislation. The 5 mistakes outlined here, failing to understand the limits of federal protection, misunderstanding state vehicle laws, mishandling traffic stops, exceeding the bounds of self-defense, and failing to research before travel, are all avoidable. They stem not from malice or from a desire to break the law, but from a lack of information or a failure to apply known information under stress. The antidote is education, preparation, and a commitment to a mindset of continuous learning. The law is not always intuitive, and it is certainly not uniform. It is a living body of rules shaped by history, politics, and judicial interpretation. Engaging with it seriously, consulting experts, reading primary sources, and thinking through scenarios in advance is the mark of a truly responsible gun owner. It is the means by which one ensures that the right to keep and bear arms remains a right exercised freely and lawfully, rather than a privilege lost through a preventable mistake on the road.